Tonight marks the beginning of a legal confrontation that, on the surface, appears to revolve around a single court order, but in reality reaches far deeper into the structure of power, authority, and accountability. What started as a procedural question has now evolved into a confrontation that challenges the integrity of institutions, the limits of political loyalty, and the consequences of ignoring the rule of law. A federal judge has formally demanded an explanation from a government official who continues to present herself as holding a powerful prosecutorial position, despite a prior ruling declaring her appointment unlawful. This is not a symbolic request. It is not administrative housekeeping. It is a direct challenge that strikes at the legitimacy of actions taken under a disputed authority. The language of the order leaves little room for interpretation. It is sharp, deliberate, and unmistakably frustrated. The judge is not merely asking for clarification, he is questioning intent. He is questioning whether the continued use of a title without legal standing amounts to intentional deception. In the judicial world, this distinction matters. An honest mistake can be corrected. A deliberate misrepresentation carries consequences. The judge issuing this order is deeply familiar with the district at the center of the controversy. He spent many years working within the same legal environment, prosecuting cases, upholding procedures, and enforcing standards that define the credibility of the justice system. This is not an outsider looking in. This is someone who understands exactly how fragile legal legitimacy becomes when authority is blurred or ignored. The issue intensified when it became clear that a serious criminal indictment had been signed and filed by the very official whose authority had already been invalidated. The case itself involves violent crimes and public safety concerns. In such matters, the credibility of the prosecution is not optional, it is foundational. If the authority behind an indictment is compromised, everything built upon it becomes vulnerable. The court's concern extends beyond paperwork. It centers on whether the judicial process itself was knowingly misled, whether a court was asked to proceed under the assumption of lawful authority when that authority no longer existed. The judge has demanded an explanation not only for the action but for the mindset behind it. Inside the institution, the effects have been destabilizing. Career professionals who have spent decades operating within established legal frameworks are now facing uncertainty. Some describe internal confusion, conflicting directives, and an environment where political pressure appears to override legal clarity. When prosecutors cannot be certain whose authority is legitimate, the entire system slows, fractures, and risks collapse. Yet this internal legal conflict is only the surface layer of a much larger and far more consequential story. Behind closed doors, a development has emerged that fundamentally alters the trajectory of everything that follows. A man who once occupied the closest possible position to presidential power has reportedly decided to speak openly, not as a defender, but as a witness. For years, he was the constant presence, the gatekeeper, the coordinator, the voice that translated presidential impulses into institutional action. He stood publicly as a symbol of loyalty, defending decisions, countering criticism, and reinforcing narratives. His proximity to power was unmatched, and now that proximity has become the most dangerous thing of all. According to detailed accounts, this former insider has testified under legal protection, providing not just statements, but evidence. Not recollections shaped by time, but records created in real time. Messages sent in the moment. Emails written as events unfolded. Phone logs documenting conversations. Notes taken during meetings where critical decisions were discussed. This is not hearsay. This is documentation. What makes this moment extraordinary is the timeline. While publicly expressing unwavering loyalty, while presenting a united front to the public, this individual was privately preserving records. Every interaction, every instruction, every signal that might one day need explanation. This behavior suggests foresight. It suggests awareness that the actions taking place carried legal risk. In power structures, loyalty often relies on silence, on plausible deniability, on the absence of written proof. What changes everything here is that silence was paired with meticulous record keeping, a quiet acknowledgement that one day questions would be asked. Under oath, the testimony reportedly reveals a pattern that contradicts public narratives. It suggests that the highest office holder was repeatedly informed of the reality of the situation, that outcomes were final, that allegations lacked evidence, that legal challenges were failing, that recounts and reviews were confirming the same result. And yet the response was not acceptance. It was persistence, a refusal to acknowledge reality, a directive to continue searching for something that did not exist. This distinction is critical. Belief can be mistaken. Knowledge followed by denial is something else entirely. The testimony suggests that this approach did not emerge gradually. It began almost immediately, before full data was available, before standard procedures had run their course. Declarations were made prematurely. Claims were asserted without verification. Advice to wait was ignored. From that moment, a narrative took shape. And once a narrative is established, actions begin to follow it. Legal challenges, public statements, pressure campaigns, each step building on the assumption that the initial claim must be defended at all costs. The records reportedly show that this strategy was not isolated. Similar approaches were taken across multiple jurisdictions. Conversations followed the same structure, the same talking points, the same demands, the same sense of urgency. Numbers were not guessed, they were specified. Requests were not casual, they were targeted. Documentation allegedly demonstrates preparation, coordination, intent. Another critical dimension of this story involves public messaging versus private acknowledgement. Statements made to audiences, preserved in speeches and publications, painted a picture of genuine belief and righteous cause. But under legal protection, that portrayal reportedly collapses. The same individual who helped promote those messages now describes them as necessary performances, not truthful reflections. When someone disavows their own published defense under oath, it signals a profound shift. It reframes everything that came before. Loyalty becomes strategy. Public conviction becomes private compliance. For legal analysts, this kind of evidence is rare. An insider with complete access. Documentation created contemporaneously. Testimony protected from retaliation. These elements combine into a form of proof that leaves little room for ambiguity. This is the moment where a political controversy crosses into criminal territory, where debates give way to statutes, where narratives confront evidence. And this shift is happening amid multiple simultaneous legal proceedings. Different jurisdictions, different courts, different standards, yet all converging toward the same central question: intent. For years, the absence of direct proof allowed defenses to survive. Doubt could be manufactured, interpretations could be stretched. But contemporaneous documentation changes the equation. It removes the need to speculate about what someone might have known. It shows what they were told, when they were told, and how they responded. As these threads tighten, long-standing assumptions begin to collapse. The belief that loyalty would hold, the belief that silence would protect, the belief that no one close enough would ever speak. As the first layer of secrecy begins to peel away, the focus shifts from discovery to consequence. Evidence alone does not change history. Evidence must be interpreted, organized, and translated into charges. This is where the machinery of the justice system begins to move from observation to action. What makes this moment different from every investigation that came before it is not the volume of allegations, but the clarity of intent now being alleged. Prosecutors are no longer attempting to infer motives from public speeches or isolated decisions. They are reportedly working with direct records that show what was known, when it was known, and how decisions were made afterward. In criminal law, intent is everything. Actions without intent can be mistakes. Actions taken with knowledge and purpose become crimes. The difference between the two determines whether history remembers a controversy or a conviction. The documentation described by investigators allegedly establishes a clear timeline. First, private acknowledgement of loss. Second, public denial. Third, coordinated efforts to alter outcomes that were already known to be final. Each step builds upon the previous one, not as a reaction to new information, but as resistance to accepted reality. This distinction is central to the charges now reportedly under consideration.